SJC-12707, Margaret Doherty v. John Gobranson.
Rossman, good morning.
Good morning to each of you. I'm Neil Rossman. I represent Margaret Doherty, the appellant in this case. I'd like to clear the deck with one issue before I get into the substance of my argument. The complaint that applies to my client is count 8 and count 9. I would concede and do concede that the decedent, Mr. O'Brien, had the right and was knowingly waived whatever rights he had for his estate when he executed the release to participate in the diving exercise. So you need not concern yourself with count 8 because I believe that the trial court correctly dismissed it. We need to focus in on count 9, which is the wrongful death count for the statutory heirs of Mr. O'Brien, namely his widow and his 2 minor children. And it's my position on behalf of the estate that regardless of what Mr. O'Brien signed, whether you want to characterize it as a covenant not to sue or an assumption of the risk, or whether you would read it as being both, it had no effect upon his statutory heirs under the wrongful death statute.
What about a release? You didn't add release to your list. What if it's a release?
If it's a release, meaning assumption of the risk, is that what you're referring to?
Sure, I'm releasing you, and we can call it assumption of the risk, but I'm not talking about a defense. I'm saying that I might have these torts available if something happens, and as it relates to duty of care, I am releasing you for duty of care. How can the tort exist when you're not exist when you're alive and somehow exist when you're dead if you release the defendant from liability? You can call it because I am assuming the risk.
Because it's inconsistent with the common law rights of the heirs at law. And there's a trilogy of cases that I would commend to the court. The first case, and they have been briefed, the first case is Madison versus California, which espoused the position that you just took, which is that the covenant not to sue did not release and did not have an effect upon the heirs' right to bring the action, but the assumption of the risk language, the release language, prevented them from doing it. And it's an inconsistent result.
Can you just, I just would like to, the overarching reason why it makes sense that the person who's actually injured and killed can waive the right completely, but his heirs, I'm just trying to understand logically why that makes sense, because the cases, he's going to argue 30 cases that go the other way, you're going to argue 30. I'm just trying, basic principle, why does it make sense for the heirs to be able to do this when he's given up all his rights? And I'm just, as a matter of just principle, why does that make sense that he can't recover, he's done something, he's released it, he engaged in this scuba diving activity knowing the risk, but his heirs still could recover? What is the logic? Just help me there.
That's the logic of the Madison versus California.
Well, but the logic is sort of these sort of legal distinctions. I'm just trying to understand principally why we would say, is it because his family is left with this burden and we should take care of them despite his release and his dangerous activities? I'm just, help me out, give me a principle why we should do this.
That's the public policy argument that's been, that was...
Is that it? Is that why we should do this? The reason is because He's left his wife and his 2 kids. He did something really dangerous. He released them from this, but he shouldn't be able to leave his wife and kids without this wrongful death action. Is that what your logic is?
That's exactly what I'm saying.
Okay, I just want to understand.
As I started to talk about the trilogy of cases, the Madison case adopts the position that was, that I was just questioned on by Justice Lowy. The second case is the Valentino case. It's a Pennsylvania case, and there's a very, very strong dissent in the Valentino case, which contradicts the logic of the Madison case. The third case, which I think succinctly and clearly and more articulately than I can espouse it, which is the Gershon versus Regency Diving Center case. It's a New Jersey case. That takes the position that I'm taking in front of this court, which is that regardless of what Mr. O'Brien signed, and regardless of what rights he gave away in order to participate in this diving exercise, he could not bind his estate and could not take away the common law rights that belong to his heirs at law by signing anything, because those rights were not his rights, and they were not rights that existed prior to his death. And
But what do you do with the wrongful death statute itself, Chapter 229, Section 2, which says that a person is liable for wrongful death only where, quote, deceased could have recovered damages for personal injuries if his death had not resulted?
again, I cite you to Gershon versus Regency Diving Center.
Cite me, but this basically says you can recover for wrongful death only if the deceased could have recovered damages himself, and you began your discussion by conceding that the estate cannot recover damages because of the release.
Let me read from Gershon, from just one paragraph. The emphasized language limiting the right to bring a wrongful death claim only in situations in which the decedent, had he or she lived, would have been entitled to bring an action for damages, pertains only to the character of the injury and is not intended as a procedural or jurisdictional requirement. And that's the position that I...
But here we have a statute which says that.
Yes, and I say that it only describes...
How are we to interpret that statutory language that I just read?
As I just commented, Your Honor, and respectfully, I say that that only describes the type of injury that is actionable. It's not a jurisdictional or a procedural bar to the common law rights of the wife and the minor children.
Now, is there any, the Second Amendment complaint, to my knowledge, when I reviewed it, did not seek any damages for gross negligence or recklessness, correct?
Well, it is negligence.
No, but for gross negligence or recklessness. You
No,
sought it only
correct.
for negligence.
Correct.
So even if the release would not protect the defendants from liability for gross negligence or recklessness, you still lose.
I say that there's a common law right.
I
Under
understand
this-
that. So
under the
let's
jurisdic-
assume for the moment that you don't prevail on that.
Yes.
But let's assume for the moment that we say, as we've said before, that the release cannot protect a defendant from gross negligence or recklessness. Do you still lose, or do you say, okay, I can amend now and argue gross negligence or recklessness? What is your position on that?
Well, all it is it's just burden shifting, in my opinion. It's taking the rights of the heirs, and it's saying that there is language that can exist, that the decedent can sign away their rights. Those rights didn't exist until they didn't accrue until his death, and that the cause of action that belongs to them remains to be tried. Their cause remains to be tried based upon the evidence. It can't be the basis of a summary judgment because it takes away a right, a remedial right that this court has recognized. It's a remedial right on behalf of the heirs and the minor children. It can't be taken away by any type of release language or covenant not to sue, because it wasn't his right, it wasn't his cause of action to release.
I guess the question is, can it be taken away by the statute? Your position is that the statute really only indicates who brings the lawsuit and doesn't limit the nature of the cause of action.
Correct. It names the takers, and then it gives and then it defines the type of compensation that can be pled. So, again, to emphasize, the progression of decisions culminates in the case of Gershon versus Regency Diving Center, and it's a case which sets forth my position far more clearly than I can do it in an oral argument. But it states the law, it states the logic, it states what I believe ought to be adopted in this Commonwealth as law, because this question has never, ever been settled. And it's a case of first impression, and it's a case in which this court ought to recognize that release language is nothing more than burden shifting, and it leaves the heirs, if you find, as the defendant would have it, it leaves the heirs and the children at the mercy of potentially welfare family members or some other private charities, as it takes away their right to have their claims vindicated or adjudicated at a trial.
Have these other cases got a statutory scheme like ours?
I'm sorry, Your Honor.
I said, have these other cases of yours, this trilogy of cases from out of state, have they got statutes like ours? Or they're not all Massachusetts cases?
I say that the statute, they're protected by the statute. It's not jurisdictional or procedural.
Okay, thank you.
Thank you.
Mr. De Magistris.
Good morning, Chief Justice and Associate Justices. Martin De Magistris for the defendant appellee, John Goldbrinson. I want to start just by referencing what I believe is the lens with which we should be looking at this case, and that is the public policy of this state versus the public policy of New Jersey, which is where the Gershon case came from, and other states that may have the same policy. In this state, Massachusetts law favors the enforcement of releases. In New Jersey, the law does not favor exculpatory agreements. Those are quotes, one from Sharon v. Newton and one from the Gershon case. So if we look at the release that was signed in this case in that lens, it is favored to enforce it.
But limited.
I'm sorry, Your Honor?
But as a matter of public policy, in footnote 12 in Sharon and in the Rafferty case, you cannot release for gross negligence or recklessness or intentional conduct, correct?
That's true, Your Honor.
So if they had made a claim, which to my knowledge they have not, for gross negligence or recklessness, you'd still have to defend against that claim.
Yes, I would concede that, Your Honor.
Which means the covenant not to sue can't be enforced because that would otherwise prevent them from suing on grounds which they lawfully may have brought.
I don't think that particular issue has actually been brought before the court. Certainly not in this case, but in general.
You're resting on the release, not on the covenant not to sue.
No, I'm resting on both, but the release in and of itself is a little more elegant because it absolves the court of having to determine whether there's an independent or derivative cause of action.
No,
because
does it
there's
really,
no
though?
duty.
Does it really? I mean, the position of the plaintiffs is, say, we favor releases. New Jersey doesn't, so we can distinguish our cases from this. But what Mr. Rossman's saying is that as a matter of common law, all the decedent could do was release what was available to him, his cause of action. Their position is that he can't release what he doesn't own. And so the fact that we favor releases doesn't really help you if we look at it from the perspective of the plaintiff's argument.
Well, I think the Madison case in California addresses that issue directly, and that is, it's not the covenant not to sue that the decedent had the power to execute. It's the release of liability. And the release of liability was his because the duty was owed to him. It was not owed to his heirs. And I think that's how the 12 states that have actually, or 13 states that have actually addressed the issue, why 12 of them, and one is against and 12 are for, because it's an almost, when you look at the black letter of the agreement, it says there shall be no duty, essentially, on behalf of the defendant to the decedent. So it's a waiver of a duty, in which case there's no tort. So I think that's how Madison deals with what your Honor's raising.
What do you make of the statutory language that the Chief Justice read earlier? Because I'm not sure I fully follow that, because the first sentence reads, a person who by his negligence causes the death of a person, that's number one, or two, by willful, wanton, or reckless acts cause the death of a person under such circumstances that the deceased could have recovered damages. Does that causes the death of under such circumstances, does that apply to negligence as well as the willful or wanton part of it?
I believe it has to, under a reasonable interpretation of the statute, because how could the legislature put a greater limitation on a more egregious act?
It doesn't make sense, but it is divided by the numbers, and it's done twice. I don't get it exactly.
Well, I think the
have we
reason it's-
interpreted that language the way you just said?
I'm sorry,
Are there cases that interpret that language being grafted onto the negligence part of this?
my understanding, my recollection is that there are cases on both sides, but primarily in dicta, that refer to the fact that it only modifies 3 and 4 and doesn't modify 1 and 2, and then others that say it modifies all 4 of them. But I go back to my original answer to Your Honor, and that is, how can you have a limitation put on an action for willful or wanton behavior that causes death and not have it apply to a lesser egregious act, which is negligence? It just simply doesn't make sense. I believe the reason there are 2 references to the decedent's cause of action for personal injury is because the first 2 subsections, 1 and 2, is referring to negligence of an individual and willful and wanton behavior, and the other is talking about common carriers, et cetera. So they're dividing it along those lines. And I believe back in 1958, and the language has not changed, it was essentially, the way it's written, I believe, was somewhat of a Scrivener's error. But I do believe that it would be absurd not to apply it to a negligence cause of action, despite the way it's written. In light of the public policy that we've been talking, or that I've raised in Massachusetts, and that is that these releases are favored, the enforcement of these releases are favored, it's telling that there's been no action on the part of the legislature to limit that. And this has been the law of the Commonwealth since for at least 90 years, that these releases are favored.
Are covenants not to sue also favored?
I'm sorry?
Are covenants not to sue also favored?
The case law that I've reviewed from the Commonwealth basically equates covenants not to sue with releases of liability, although distinguishes them as being technically separate.
But the public policy you're saying is the same.
Yes.
But not all releases are enforced, right? I mean, you can't contract your way out of the workers' comp laws, right? You couldn't say, I mean, we have releases, contractual provisions that are going to be violations of public policy, right? for example, if this person got hurt at work, he would still be able to recover workers' comp, right? Even if there was a release, right? If this were a fellow scuba diving instructor, I'm just not sure I understand how
Well-
far releases go.
If it was in the workers' compensation scenario, there are basically statutory requirements of what an employer or an insurer is required to do under those circumstances. And that sets forth the public policy with that scenario. One of the public policy indications that the legislature's made with respect to these cases is with respect to loss of consortium in the context of workers' comp. When Ferreter, decided by this court, was overturned, well, essentially abrogated by the legislature by removing loss of consortium claims in those contexts.
I'm not
So,
sure, finish, I apologize for.
I am finished, thank you.
Oh, okay. So I understand the answer to my question, but it doesn't really answer my question. So it may well be that you're right. Well, the cause of action belonged to the would-be plaintiff, the decedent, who signed the release. And how can the heirs have something that the decedent didn't have? And he made the release. I understand your position, and that maybe that's right, but it doesn't address the plaintiff's argument. That release does not address the plaintiff's argument. The plaintiff's argument is, no, the cause of action belongs to the heirs, and you can sign 50 releases. You can't release what they own. So I appreciate your answer, but it doesn't address their argument.
And let me try again. The reason I referenced Madison and those line of cases is because Madison addresses that issue by saying, yes, you cannot take away that cause of action on behalf of the heirs. They're not signing the agreement, and it's not your right to give away. What is your right to give away is a duty owed to you.
Explain that again. I'm missing that.
Sure. We're talking about a covenant not to sue in which one states, I waive a claim for wrongful death. I waive a claim for personal injury. As opposed to, I release you from any liability to me, in which case there is no duty owed. So if you're absolving someone of a duty, the wrongful death claim can technically still be filed by the heirs. It just constitutes a complete defense because there was no tort. And I also want to just point out briefly that there's been a lot of discussion in the briefing about
Can I, before you leave that point, because that seems, and like Justice Lowy, I'm trying to understand that. So your brother, I asked in the beginning, okay, what is the fundamental principle is that these people have their own separate right of recovery, that even though, the scuba diver himself was doing something dangerous and waiving liability, these people are left to sort of clean up the mess. And the statute somehow wants them to be able to recover. Why is there still no separate duty owed to them? Because absent the release, I understand he would have a claim. He might have a claim. And if the release is sort of limited to him, but I'm just trying, again, I'm trying to understand the sort of fundamental logic of this, because the cases are all over the place and not very helpful.
Well, I think to start with, Your Honor, you referenced the statute. You said, and I hope I don't misquote you, you said something along the lines of the statute wants these people to have.
Well, I'm interested in the chief's sentence. If that sentence makes this simple and everything goes away, then the legislature addressed this. The problem is that sentence is broken up in a way that confuses me.
So, that's the point I'm getting to.
Okay.
If you apply that is a statement essentially of public policy by the legislature addressing exactly what you're talking about.
Right.
The public policy statement made in that statute is that, yes, the heirs do have a cause of action that can only be brought by a certain person, the administrator or the executor, et cetera, et cetera, et cetera. However, if the decedent does not have would not have had a personal injury claim for the same accident, then there is no wrongful death claim.
Is that because of that sentence that the chief read, that it has to, that caused the injury to the plant, whatever that language is that we read earlier? The one that limits it to him, sorry, it's number 2. Causes the death of a person under such circumstances that the deceased could have recovered damages for personal injuries. Do we need to read that into clause 1 to understand the legislature's intent here?
I think it's essential to read it into clause 1 because by necessity, it has to apply to clause 1 in this context, for the reasons I stated before, that it would be absurd not to read it into clause 1. So yes.
But what's strange about the statute, which I had missed when I first read it, is then you go to section 3 and 4, which provides a wrongful death where 3 operates a common carrier of passengers and by his negligence causes the death of a passenger, or 4 operates a common carrier of passengers and by his willful, wanton, or reckless act causes the death of a passenger under such circumstances that the deceased could have recovered damages for personal injuries if his death had not resulted. So the legislature did it twice.
Under the same scheme, I believe, Your Honor. I believe it's under the same.
It's just, it is interesting that they seems to have included that phrase with regard to willful, wanton, or reckless, but not with regard to negligence. What meaning should we take from that?
The meaning that the 2 sections, and what I mean by that is subsection 1 and 2 relate to negligence and willful and wanton, one on behalf of individuals and one on behalf of common carriers, et cetera. And I think they take the clause referring to the decedent's cause of action to apply to both of those. And then 3 and 4 relate to, I'm sorry, I think I reversed it, but essentially what I'm saying is clause 2 and 4 apply to both 3 and 1 respectively, and I think the scheme was, before they put numbers in, was to have those apply to all 4 subsections. And again, we obviously don't interpret statutes to reach absurd results. There has to be common sense in our interpretation of statutes, and it simply doesn't make sense if you don't read that into it.
Okay, thank you.
Thank you.